Working with Congress, reading on page 259. The system of checks and balances often places the President against Congress. This problem is quite challenging when the President's party is different from that of the majority party in Congress. Despite their differences, the executive and legislative branches must cooperate. President Lyndon Johnson described the role Congress played in his work. Although Congress passes law, the President can ask members of Congress to pass or reject certain bills. The President also has the power to veto or cancel laws that Congress passes. Congress can override or undo a President's veto, however, doing so is very difficult. Overriding a veto requires a 2/3 majority vote. After Congress passes a law, federal agencies and departments often decide how to reinforce it. In carrying out laws that affect parts of the Constitution, treaties, and statutes, the President may issue an executive order, a command that has the power of law. In an emergency, the President might issue an executive order that stretches the definition of laws passed by Congress. The President also has the power to grant a pardon or freedom from punishment. Pardons are sometimes given to persons convicted of federal crimes or who are facing criminal charges. Turn the page. The President is also Commander-in-Chief of the Armed Forces. In an emergency, the President can send the U.S. troops, but only Congress can declare war. Some other executive duties are foreign relations and arranging treaties. Currently, 14 executive departments do most of the executive branch's work. The President chooses the department heads, whom Congress must then approve. The Cabinet, made up of these department secretaries, advises the President on important matters. The Supreme Court, at the bottom of page 260. After a case has been decided by the Court of Appeals, the losing side may appeal the decision to the Supreme Court. Thousands of cases are appealed to the court each year. However, Supreme Court justices have time to review only about 100 of these cases. The justices carefully choose which case to hear. Generally, cases that are chosen must involve an important constitutional or public interest issue. If the court refuses to hear a case, the decision of the Court of Appeals is final. Most cases that are presented to the Supreme Court are review cases. However, some cases go directly to the Supreme Court. Some examples are cases that involve international diplomats or disputes between states. Congress decides how many justices sit on the court. Traditionally, that number has been fixed at 9. The Chief Justice of the United States leads the Supreme Court. Unlike the President and members of Congress, court justices do not have specific requirements set by the Constitution. So far, however, every justice has been an attorney. In the past few decades, the makeup of the Supreme Court has become more diverse. In 1967, Thurgood Marshall became the first African American justice, with Clarence Thomas becoming the second in 1991. Right now, 2 women sit on the High Court, Ruth Bader Ginsburg and Sandra Day O'Connor. O'Connor became the first female court justice after her 1981 appointment by President Ronald Reagan.